Good afternoon, Senator McDonald, Representative Lawler, and members of the esteemed and distinguished Judiciary Committee. My name is Martin Looney, represent the 11th Senatorial District and Senate Majority Leader. I'm here to express my support for a number of bills on today's agenda. First of all, Senate Bill number 349, an act concerning the penalty for possession of a small amount of marijuana. Also, Senate Bill 348, an act concerning the videotaping of custodial interrogations. Senate Bill 357, an act concerning eyewitness identification. Senate Bill 673, an act concerning access to the Criminal Justice Information System. Senate Bill 707, an act concerning probation supervision fees. House Bill 6581, an act concerning enhanced penalty for sale or possession of drugs in your schools, daycare centers, and public housing projects. And House Bill 6708, an act concerning criminal cases of persons who have returned from service with the armed forces that Commissioner Schwartz had just testified on. Last year, the state of Massachusetts passed by referendum a measure which decriminalized the possession of an ounce or less of marijuana, and that measure passed by nearly 65% to 35% vote. Polling in our state by Quinnipiac University demonstrated that 58% of our citizens here in Connecticut favored decriminalization for possession of small amounts of marijuana. Senate Bill 349, which would decriminalize possession of less than an ounce, represents, I believe, a compassionate and pragmatic policy. Our state should not encourage illegal drug use. However, possession of small amounts of marijuana for personal use should not leave a person with a lifelong criminal record. The bill would also create budgetary savings, would reduce costs to police departments, the court system, the offices of public defenders and state's attorneys. The Office of Fiscal Analysis estimates it would save $11 million and generate about $320,000 in general fund revenue annually. This is an issue like medical marijuana, where the public is ahead of elected officials in terms of their perceptions about what is or is not acceptable. Also, I've long been an advocate for the taping of custodial interrogations, as this procedure protects both police and suspects in the interrogation process. And Senate Bill 348, an act concerning videotaping of custodial interrogations, would move our state in this direction. While historically law enforcement officers have viewed taping of confessions with some trepidation, once they begin the process, many of them become advocates for it. Our Chief State's Attorney, Kevin Kane, has been helpful in increasing the use of taping custodial interrogations and has become an advocate within his system. If you would like more information on taping and the positive response from law enforcement, there's a law review article from Northwestern University School of Law, Police Experiences with Recording Custodial Interrogation. Be happy to share that with you, and that this taping would ensure greater accountability in our judicial system. Senate Bill 357, an act concerning eyewitness identification, would represent another improvement in the accuracy of our system by addressing the notorious conundrum of eyewitness identifications. Everyone involved with the criminal justice system, as we know, is well aware that eyewitness identification can be a double-edged sword. It's prone to stunning inaccuracy, but it also is perhaps the most compelling testimony in a courtroom. Therefore, we have an obligation to ensure that this testimony is as accurate as possible, and Senate Bill 357 would reduce the probability of error or undue influence by law enforcement by requiring that lineups or photographs be shown in sequential order rather than simultaneously, and that when possible, the person conducting the identification procedure should not know who in the lineup or photographs is the suspected perpetrator, and that the fillers in the lineup generally fit the description of the suspected perpetrator. This proposal would increase confidence in the investigative techniques used within our system. Senate Bill 6581, an act concerning the enhanced penalty for sale or possession of drugs in your schools, daycare centers, and public housing projects, would address the issue that in cities such as New Haven, there are very few places that are not within 1,500 feet of a school, daycare center, or public housing. This creates a situation in which almost any sale or possession of illegal substances in the cities is subject to the enhanced penalties, as opposed to such activities in suburban communities of larger area. This bill would lower the distance to 250 feet and make the enhanced penalties apply only when the facilities such as schools or daycare centers are in fact open. Also, Senate Bill 676, which I introduced, an act establishing a special criminal docket for military affairs, is substantially equivalent to House Bill 6708, which is on the agenda here today. As we all know, persons returning from service face many special needs, and a system similar to this has worked quite well in Buffalo, New York, which has become the model program. And I believe that our Commissioner Linda Schwartz, as we know, is an advocate for this and testified in favor of this concept this morning. Also, Senate Bill 673, an act concerning access to the Criminal Justice Information System, would allow the federal defenders the same access to CGIS as state public defenders have. This change would represent fairness as the U.S. attorneys have this access. And finally, Senate Bill 707, an act concerning probation supervision fees, is a common sense change and would require that payment of these fees not be required until the person is released from confinement and begins a period of probation supervision. Thank you to this committee for raising these bills to improve our criminal justice system, and once again, this committee is at the focal point of so many important issues for our General Assembly. Thank you, Mr. Chairman.
Thank you, Senator Looney, and we certainly were looking for some work, so appreciate you bringing forward these proposals. Some of which are proposals only lawyers could love, but are very important, such as the lineup bill. And I just wanted to ask you briefly with respect to the Senate Bill 349, possession of a small amount of marijuana. And I apologize, you testified that there was a potential of $11 million of savings. What was the source of that?
Yes, there's a fiscal note dated yesterday that indicates that based on a proportionate analysis of resources currently allocated to handle these offenses, estimated the proposal could save up to $11 million and generate about $320,000 in general fund revenue annually for the infraction fines. And that's based on prorating the number of the Superior Court handles about 3,200 cases each year under General Statute 21A 279C, and that deals with possession of less than 4 ounces of marijuana. And assuming that possession of less than an ounce accounts for a quarter of these cases, they were able to apportion costs and savings along those lines. Estimates are in Massachusetts that there'll be savings of about $30 million a year for law enforcement based upon the matter that was passed in referendum. And since our state is approximately less than half the population of Massachusetts, our OFA estimates that the savings would be about $11 million in Connecticut.
I haven't. Thank you. I haven't seen the fiscal note yet. Does the fiscal note take into consideration the whatever would have been gained by the fines that would have otherwise have been? I mean, is there a revenue loss on the fines, or is that netted out to be $11 million?
I think that's netted out. I think there's their presumption in the fiscal note that more cases would be resolved with because of fines rather than under current law, where it often results in probation of one kind or another, or incarceration. The note does indicate that there are about 1,300 probationers currently under supervision in the community with possession of less than 4 ounces of marijuana as their primary charge. Again, assuming this would be about a quarter of the cases would be covered under this provision, there would be the savings of about $425,000 in that category. Also, there are about 57 inmates serving a sentence where the controlling charge is 21A 279C. Again, it has prorated savings based upon that, as well as the fact that there were about 9,928 marijuana arrests in Connecticut overall in 2007, representing 7% of total arrests statewide, and approximately 33% of these were for possession of less than 1 ounce of marijuana. Again, there would be significant savings within the public defender system, because we know if someone is charged with only charged with an infraction, they're not eligible for the services of the public defender as they would be when charged with a felony or misdemeanor.
Well, thank you very much, Senator Looney, and you and I have had a chance to talk about some of these other issues. I hadn't known about the fiscal note, so that's why I wanted to explore that. I appreciate it. I also want to congratulate you on the proposal for the Veterans Affairs docket, too. That's very, very important.
Thank you, Mr. Chairman.
Representative Fox?
Thank you, Mr. Chairman, and thank you, Senator Looney, for your testimony here this afternoon. I have a question on Senate Bill 349, and as I understand it, the way it currently works for first-time offenders of small amounts of possession of marijuana, they would be eligible for the court's drug education program, and then there's also the community service labor program. Is that?
That's generally the case, although that's often first-time offenders of possession of small amounts are eligible for one or the other of those diversion programs under current law.
Okay.
Although, as we know, since there are some people serving sentences for this offense, those people may or may not have had benefit of the programs earlier.
Yeah, no, that's some people you don't know why they were denied, or if there could have been a reason why
Yes.
the application didn't go through. And those programs, as I understand it, they also include cocaine or crack cocaine in addition to marijuana, which you're proposing here only includes marijuana.
That's right. This is limited only to marijuana,
Okay.
and not to any of the other substances.
Okay. And what kind of sentences do you, if you know, that are people traditionally serving when it comes to a possession of marijuana charge, if they do reach the point where they're sentenced?
If they are, many of them are serving sentences of 6 months to a year, I think, in cases where it does get to the point where they are incarcerated. Yeah.
Okay. And also, just so I'm clear, your proposal does not do anything with respect to either sale of or intent to sell?
Oh, no, no.
Okay.
Anyone who is charged with that would not be would be charged with the current law, the current criminal offense. It would not in any way change anything other than the possession, simple possession of the small amount of marijuana would not make any changes in our laws relating to possession with intent to sell.
Okay. Well, thank you very much, Mr. Chairman.
Thank you.
Thank you very much, Mr. Chairman. Senator, it's always great to see you.
It's good to see you, Senator.
I remember the glory years when you and I were working here on this committee together. And I also want to commend you personally on the veterans proposal. I think that's just its time is now, and it's a great initiative.
Thank you. From what we hear, the court that was set up in Buffalo has had very gratifying results in helping veterans.
I think it's fabulous. Regarding the videotaping of custodial interrogations, did we establish a working group regarding that? And I think they were going to try to come up with a pilot. Are you aware of that, or is my recollection having to do with perhaps something else?
There was I think a pilot set up. Initially, it was that Mr. Morano was working on it, but then Chief State's Attorney Kane has taken it over, and he has been very instrumental in helping to try to get voluntary compliance in a number of police departments in the state. So it is starting to catch on. I think that traditionally police had believed that in some ways it was a pitfall for them, but increasingly they're I think coming to recognize that it has benefits for them as long as the interrogation is conducted properly. They are protected by that extra evidence as well.
Okay, very good. So assuming that we get the Chief State's Attorney here to testify, and I think I saw him in the room, I'm looking forward to hearing how that's going along. Regarding the
it's also, as you know, a funding issue in terms of being able to for the departments to buy the equipment and have it on hand. Right?
To my mind, Senator, that's always been the biggest stumbling block. I think while there had been some philosophical differences in my recollection over the years of the concern raised by police departments is the funding issue, the space issue within the department, how to adequately or properly train the staff to videotape and things like that. Regarding the marijuana, it's an interesting proposal. I know that Massachusetts, which does have referenda that goes to the public, and I support referenda. Granted, we can rely on Quinnipiac polls, but it would be great to get the direct votes of the public on some of these issues. But if we decriminalize possession of marijuana less than an ounce, would that not have the effect of encouraging drug dealers? Because if there's no real penalty for possession, if it's an infraction, and I read the bill and it's basically like getting a parking ticket, then there's going to be, in my view, probably more consumers, because they're not going to be as fearful of the law and the effect it would have on their record, and therefore that there would be more drug dealers out there trying to sell to individuals, because those individuals might not be as fearful of the judicial system, because if they get caught with less than an ounce of marijuana, they're just going to get a ticket.
I don't think it would necessarily alter consumption patterns. People are either going to use the substance or not, based upon other factors in their lives. But I think that that really what it would do is, as the people in Massachusetts were persuaded, is that it will save the casual user from having a criminal record that will follow him throughout his whole life for possession of something that is, I think, a very minor offense that is more properly treated as an infraction rather than a criminal violation. Now, obviously, there are ways to leverage repeat offenses into something more serious, as we have now with the persistent larceny offender laws, where you have a case where under our current law, someone who was arrested for shoplifting under larceny 6, but has a number of convictions of that larceny 6. After a while, at some point, a decision may be made to prosecute them as a persistent larceny offender. We could structure the law in this case that somebody who has a certain number of convictions of infraction convictions of this kind could then be charged with a persistent marijuana offender, leveraging into a more serious offense, as we have precedent for in other areas of the law.
Okay. Similar to getting points on it for driving.
Similar to getting points on your license that have a cumulative effect. Right.
And my other question is, you know, and a proposal that I had supported this legislative session to try to get the state about $15 million is Sunday sales of alcohol. And it's my understanding that Connecticut banned Sunday sales of alcohol based upon law that was passed in 1933 at the repeal of Prohibition. And then if you go back to the beginning of Prohibition, it was just one of our blue laws where we banned all sorts of things from taking place on Sundays. It's my understanding that most recently, in the last 10 or 20 years, automobile dealers had to go to court to win back the right to be able to sell automobiles on Sundays. That was caught up in the blue laws. And it seems like sale of alcohol is the last blue law we have on the books where for a variety of reasons, not the least of which is some package store owners don't want to have to work on Sundays, which I appreciate that. But it's a real mixed message that we're sending to the public if, on the one hand, we as a state still are going to ban the sale of alcohol on Sundays, and on the other hand would be essentially decriminalizing a drug that has psychotropic propensities, and I've heard many experts say is a gateway drug to experimentation with other drugs. And how would you reconcile those two things?
Well, as we know, alcohol has always been treated differently than other substances that, and it can sometimes cause as great harm as those other substances. And but historically, we had the experiment with Prohibition that didn't work out all that well because there was such a large public rejection of the banning of that of alcohol that it was created criminal enterprises because the market continued to exist despite the status in the law. But obviously, I think that Sunday sales is also under consideration this year, and perhaps that issue will get changed in this session as well. I know it has strong opponents and also some opponents, but you know, I could see that as certainly arguments being made for that as well.
I guess that answer leads me to one last point. Always enjoy working with you, Senator, and very interesting to debate these issues with you. On the marijuana issue in particular, is your support based more on the financial ramifications, or do you feel it's also a matter of fundamental justice that our laws are too strict for possession of marijuana in quantities less than an ounce?
Well, it's both, Senator. This year, of course, we have an unprecedented fiscal crisis facing us, so that's one motivation. But the other is somebody who does criminal defense work in my private practice. I have seen many people caught up in the criminal justice system for these relatively minor offenses, and in some cases it's had devastating effects on their lives.
Thank you so much, sir, and I look forward to debating these issues further in the weeks ahead.
Thank you, Senator.
Representative Dillon.
Thank you. Good morning, Senator Looney. I guess first I want to thank you for your leadership on a lot of these issues and for the quality of just a number of positive proposals that you've put forward. You know, whatever people agree or not, you're looking for remedies, and I think that's important. And I guess I just want to say in passing that ever since that episode at Cheshire, I've really been troubled about the things that we do here in this building. It seemed to me that we were spending a lot of our energy in this building figuring out how to put people in prison, but that our system had lost the ability to evaluate risk, that we were packing all these people into prison, and it wasn't even clear to me that they were a threat to society, and yet we had these people coming out that a judge had identified as a psychopath, and we were not putting any money into the other side. So that I didn't have a great answer for that, and I think that the choices that we made, some of them I think were better than others. Making a full-time parole board was very important, and in fact it's shocking that we hadn't done that. But I think the proposals that you've put forward on the penalties on marijuana are interesting, because I had a couple of constituents whose kids, who were in private schools, had gotten caught up in that, and there was a tremendous amount of pain to the family, but they were able to sort of get them out of the system. And there are some others with lesser access, I guess I might put it, where their kids did not. And so that it seemed to me on the ground that there were some problems in terms of the fairness. And I don't know if has that been your experience as well?
Yes, it has, and obviously, in some cases, we know that people who go into court charged with possession of small amounts are offered the diversion programs if they're first offenders, and certainly that's almost always the case if you're represented by an attorney. But it's not always the case if you are a pro se defendant, and there have been lots of people I've heard from years later who said, well, I pled guilty to this charge, I represented myself, I didn't know there were other options available, and prosecutor just said, if you plead guilty, we'll give you a fine, and they did. And unfortunately, they were sometimes not informed of the other options available to them if they had sought counsel, if they were not eligible for the services of a public defender, but yet not able to hire private counsel. They often did not benefit from diversionary programs.
I was thinking of that because I've gotten a couple of requests from constituents as the economy has gotten worse, from folks who are looking for work and are anxious about criminal background checks, which you need for almost everything now, and they vary, and what it really makes you is unemployable. And I don't have the answer for all of this, but I guess I want to thank you for putting this forward. And on the docket for veterans, I think that's a great idea as well. As you know, I think there was an OLR report a while ago that looked at the number of people who are in our correction system who had military exposure, and I guess I want to thank you for that as well. Years back, on the issue of possession, I think if you were possession or sale, you had an exemption if you were. The court could take into consideration if you were an addict, and I remember a big flurry in the House to remove that provision, because there was a psychiatrist in Waterbury who was charging people to say that they were addicts when in fact they weren't. They were predatory dealers who had no addiction. And that was taken out. I thought the remedy was to go after the Waterbury psychiatrist, but instead there was a tremendous amount of drama on the House floor, and mostly coming from that particular delegation, and we all voted for it. I understand your sensitivity on this issue, and that you wouldn't necessarily want to go after the dealers and the intent to sell, and therefore you've fallen back on something which is much more modest. But I just wonder whether sometime we might want to go back to the old law 10 years ago. I'm worried that there are violent people on the streets because of overcrowding when we're locking up some addicts who are not. I don't know that, but I want to look at it.
Right. Good. Thank you, Representative.
Further questions? Representative Walker.
Thank you, Senator Looney, for all of the bills you put here. They have thought, and they actually make us look at things outside the box, and we need to start to do that, especially when it comes to our criminal justice system. There are two bills that just I was amazed at, and the Senate Bill 707, an act concerning prohibition of supervision fees. We expect to collect fees from people while they are incarcerated?
My understanding is that sometimes that does happen, that they are billed for it at a time when they don't yet have the resources to pay. Often that is deferred, but this would make sure that in fact, that the payment would be deferred until they presumably have the ability to pay.
Do you know if we actually have prosecuted anybody or sent to collections or on anybody while they were incarcerated in order to try and obtain any fees? Do you know anything?
That I don't know of. I believe the Public Defender's Office may have some information on that.
Okay, because when I read that bill, I was stunned. And you're right, it is common sense. And the other one, an act concerning access to criminal justice information system, Senate Bill 673. Do other states allow the U.S. attorneys, defenders to access their records? Is that correct?
I believe they do, and what this would just provide that the federal public defenders would have the same access that the federal prosecutors now have.
But other states do allow that.
I believe so. I believe that's parallel in some other states.
And the last one is the one that that proposes a reduction of from 1,500 feet to 250. I know several states have done that change.
Yes.
I believe New Jersey's done it, and a couple of others.
Yes, I think that's right. A number of states where you have lots of densely populated urban areas are considering that, because in effect it creates a kind of heightened liability just based upon geography, living in a dense or less populated area.
It's not saying that we're being soft on crime. It just means that we're being realistic about the density of the community.
Right.
Thank you very much, and thank you for your leadership, sir.
Thank you, Representative Walker.
Representative Conway.
Thank you, Mr. Chairman. Good afternoon, Senator.
Good afternoon, Representative Conway.
With regards to 349, just some questions in terms of the fiscal note, which we don't have, we don't have access to, but to the 11 million. You had mentioned that 9,900 arrests overall in the past year for possession, and 33% of those with possession of less than 1 ounce. And do we know of the 33%, how many actually were then convicted and incarcerated?
On the fiscal note, Representative, it does make reference to the, see if I have that part of it here. The fiscal note said there were 9,928 marijuana arrests in Connecticut in 2007, representing 7% of total arrests statewide, and then based on prior research findings, it's estimated that approximately 33% of those arrests were for possession of less than 1 ounce of marijuana. This results in an estimated 2.3% of total law enforcement resources statewide that are currently allocated to these cases. And so based on the above, the theoretical savings to state and local law enforcement agencies is estimated to be $9.4 million, resulting from savings associated with police officers no longer having to process arrests for possession of these small amounts. And see if there are any other figures related to that. It just overall that there are. Yes, so in the fiscal note, it tries to prorate the number since the statute relates to possession of 4 ounces or less. The fiscal note tries to prorate costs down based upon a 1/4 factor in those cases to try to come at a dollar figure for fiscal note purposes.
So we don't know then of that 33% that were arrested for 1 ounce or less, how many actually were convicted and then incarcerated for that charge.
No, another portion of the fiscal note, Representative, just say that there are currently 57 inmates who are serving a sentence where the controlling charge was 21A 279C. And there are 17 offenders being held pre-trial, and that it estimates that that's, of course, there are many people who are serving sentences who had multiple charges, but so there are 57 where the controlling charge was was possession of less than 4 ounces of marijuana.
But we don't know how many were less than 1 ounce.
No, the fiscal note estimates again approximately 1/4 of those, presuming in that an average cost of nearly $45,000 per year. This estimated savings would be $831,000 per year based on that prorated estimate.
So we're guessing out of those that were arrested for 4 ounces or less that maybe 25% were for 1 ounce or less, and that was the controlling charge. But was that their actual incarceration, maybe a plea down from a more serious charge to the charge of 4 ounces or less? Might have been one of many charges that they then pled to?
Don't know how many. Obviously, overall, there were 9,900 total marijuana arrests in Connecticut in 2007. That does not discuss the number of cases that were actually resolved with pleas on that or other charges.
And I'll just follow up. Are you, you've been here a long time, and I, very new. Medical, marijuana for medical purposes, has that bill come before this committee or the legislature in prior years, do you know?
I believe it has. Obviously, the chairs of the committee could talk more about that.
And what has been your reaction to that, or have you had an opportunity to testify for that particular bill?
Well, that's a separate issue, but I believe I have supported it in the past.
Okay. Thank you, Senator, very much. Thank you, Mr. Chairman.
Thank you.
Representative O'Neill.
Thank you. In one sense, I look at the proposal about the marijuana, and it's almost like we're just codifying current practice, because when you start out with 9,900 arrests for marijuana and you only have 57 people incarcerated, I'm not quite sure what the ratios are for everything else, but that's got to be a very, very tiny percentage of people that actually get incarcerated after they've been arrested. So in one sense, it almost looks like this bill just codifies what must be the current practice, which is that almost nobody goes to jail for marijuana possession. But a couple of things occur to me, and that is, one of them is that I'm curious about how the police are going to, because part of the savings, the police savings, seems to hinge on issuing a ticket kind of approach as opposed to arresting and processing someone. And I'm just wondering, how are the police going to know whether the substance they're arresting the person for is marijuana or something else? And second, how are they going to know that it's below 1 ounce in effect in a field situation of marijuana?
Well, I think obviously police training, expertise, and judgment and discretion will come into play. But obviously police are generally skilled at looking at a packet or bag or individual marijuana cigarettes and determining what generally represents an ounce on the street. It'll be a matter of practice, protocol, and training, I would imagine.
So in other words, whether somebody gets an infraction or not is, if you get a rookie who just started work the day that he meets you, he might arrest you thinking, I can't be sure if this is an ounce or not, so I'm going to arrest you to be on the safe side because it might be 1.5 ounces. And you get to go through the process and you get processed, and if you're a 20-year veteran and you feel pretty confident that this is less than an ounce, that person just gets the infraction.
Well, I think over time this will work itself out in practice, and if something is in fact less than an ounce, it would be determined later to probably be eligible for the infraction.
But the processing fees, costs to the state would all have been
incurred
lost
at that point.
Yeah,
right.
we would have still spent the money because you have to figure out whether it's not. Okay.
That's right.
Because my understanding is that we send things to laboratories and we have tests of it's been a long time since I've done criminal defense work, so I can't remember all the details, but since you do that as part of your practice, am I correct in that in order to determine whether something is a cannabis substance or not, it gets sent to a laboratory?
Generally, it is. Sometimes it is. The initial charge is lodged before that has happened, though.
Okay, so somebody's making a guess as to they think this is cannabis based on their 20 years experience as an
Yes.
officer and that sort of thing.
Right.
and then later it's determined that it's not. But if he doesn't make the initial charge, then the stuff is never sent to a laboratory to be tested. So in other words, the only ones that get tested are the ones where people got arrested in the first instance.
Generally, I think so.
Okay. But in this case, none of the substances below the ounce level will ever be sent to a laboratory, I assume, the way this is going to work out.
That would have, we could work that out in terms of figuring out the details of implementation, but obviously you would assume that the officer will certainly take possession of the items. Person would not be left with the possession. It could still be processed to make a later identification of the actual content.
Okay, so, because that wasn't clear to me as to what would happen. You just issue the ticket and walk away, or then we pick it up, take it to a laboratory, and that processing cost presumably would potentially be still there as an unrealized savings.
Yeah, one of the things we're looking into the Massachusetts statute and seeing how that's being handled there, since their law went into effect just a couple of months ago.
Mm-hmm. Because one of the concerns that in reading about what's going on in Massachusetts, I think, and I may be, because I read too much, but I think I got the impression that basically they're not arresting anybody for possession of marijuana based on that situation. I mean, unless you've got a tractor trailer, but I mean, individuals walking around with packages that they would have on their persons, that the police basically aren't bothering to arrest anybody. I'm wondering if that's going to be what happens here, that it seems like it's taking the edge off of pursuing this kind of investigation. Okay, thank you.
Anything further? If not, thank you very much, Senator.
Thank you, Mr. Chairman.
We have time for one more